in the construction trades? Earn while you learn.
Workforce, because it was one of those deals where it was a customer service, and if you had a problem with the software, you could log on, talk to someone to figure it out. Well, the average wait time to be dealt with by a human was like 2 hours and 14 minutes. With AI, it was 3 minutes and like 15 seconds. So he's like, look, I hate to do this, but you can't, humans can't do the job in this fashion. It absolutely can't. But so it just wonders, I feel like we talk every week, Ed, about the different ways that AI is being used, and the more and more it's making people obsolete.
Right. And in this case, we're talking about Sarah Silverman, the comic, and a couple of authors are suing Meta and ChatGPT over using OpenAI, which basically is saying that, because it has so much data infused in these things that, okay, that includes their stuff. Well, now it's writing comedy in the form of what Sarah Silverman thinks is something she might write. And these authors are going, wait a minute, I already wrote that book.
Right. Yeah, it's crazy.
So let's talk to the guy we love to go to in these situations, the patent professor, our good friend John Rizvi. And John, this is going to take a long time to sort out, isn't it?
It is going to take a long time to sort out, and I think ultimately it's going to have to, there's going to have to be new laws that are made specifically to stop the huge wholesale type of copyright infringement that ChatGPT and AI permits. I mean, it's the cases that are pending now. If they actually go through trial and infringement is found, it will clearly make OpenAI or ChatGPT the biggest infringer pretty much in the history of the world. It's just the amount of data that this software is crawling and ingesting is just so huge. There's no human has been able to infringe at this scale before. The expression like humans make mistakes, but to really mess things up, you need a computer. This is wholesale infringement. This is like at a scale that we've never seen.
Wow.
So, John, what you just said begs the question: how do you sue a robot?
Right.
Well, it's fine. I mean, you have OpenAI, which is the company that created ChatGPT. So they are the ones that are the lawsuit is brought against. And same thing with Meta. So you sue the people who are controlling the software and the computer. So until we get to a point where you have robots that are not owned by anyone, then I think we've got somebody to sue.
Gotcha. So I guess what I'm trying to wrap my brain around is, I understand if you're in college and you're asked to write a term paper on World War II and you use ChatGPT or OpenAI, whatever, and it generates that for you, because in that you have to have listed sources, you have to have all that, and there's software that can detect yada yada. But when it's, in this case, say it's a joke, they're not stealing her actual jokes that she once used. They're just stealing jokes because it's so smart, it knows her style.
Right.
So I guess, people for the longest time have said, yeah, I've copied my guitar playing style off of Eric Clapton, or I've copied my comedy act off of John Candy. But so what's the difference between saying, hey, I've watched her my whole life, I know her style, so I kind of went with it, versus what's going on with ChatGPT?
Yes, you bring up an interesting point. I heard something recently. They say when people do it, they say they're inspired by, and when a computer does it, it's suddenly infringement. And part of that comes down to when you have intellectual property as a copyright holder, you are the person who has the right to determine when, where, who, and gets to use it and how they get to use it. The central theme to all of these copyright infringement suits against ChatGPT and OpenAI and Meta is that they never provided permission for this software to ingest their work, and that the only way possible for this software to provide the kind of detailed summaries of in the case of Sarah Silverman, her book, The Bedwetter. The only way this software could provide that summary is if it had ingested the entire book. And it wasn't licensed. It wasn't sold to the software. They don't have permission. And the similar vein is that when you gave that example of not copying the joke, but copying the style, that brings up and a style maybe inspired by a comedian. The only way this software would really know the style is if whether a comedian or an author of a book, is if they have somehow ingested the book and permission was never provided. It's different. That's the sole difference between, when a human being, reads a book and then writes up a summary, they've have a license to read that book. They've either purchased it or they've gotten it from a library, or there's a first sale doctrine, which means they've either been given the book by somebody else who has obviously paid for the book. So the author ends up one way or another getting compensated. With ChatGPT, that's not the case. So the authors are not being compensated for their book being crawled, and sometimes it's what they're calling shadow libraries, which are not authorized libraries online that have the author's book, and the software crawls, takes that data, and that's the only way they're able to summarize the contents of that book. So,
and we're talking to John Rizvi, and John, you've been saying it's crawling around. Now, that's what I wanted to ask you. So nobody's inputting this stuff in there. Nobody's saying, okay, I want to download Sarah Silverman's book into this thing. So, that data will be there. So this thing's just crawling around online looking for stuff to ingest. Is that what I'm hearing?
It is, and it's funny. I mean, the term ingest just comes from the complaint, and I think nobody knows what else to call it, right? It's so the term sticks. It almost seems like it's eating the work. It's crawling the online and eating the works of these authors, right? Like that's what ingestion is, or ingesting something is. And that permission was never provided. And that's the authors, whether it's Sarah Silverman or these other authors, Mona Awad or Paul Tremblay. That's their central argument, is that it's copyright infringement because permission was never provided.
I guess, you could sue ChatGPT, but there's no way you could ever, I know comics get pissed when people rip their material off, but even this is a much, much easier way to rip their material off. But there's no way you could prove it. They could say, like what you just said earlier, well, I've been inspired by you. I know how you like to tell jokes, and I like to tell them in the same way, and so that's what I did. It's such a nuance, but it's so hard to kind of keep track of.
It is. I mean, you think of by Stephen King, like his horror stories. Like if someone's inspired, a human being inspired by him, and starts writing stories that kind of have that same basic style, but they don't take, like for example, Pet Sematary. They don't take the storyline. They don't take the characters. But you could read that book and you feel like you're reading Stephen King, but you're not. When it's a human being, it's really hard to find anything actionable. Now, when a ChatGPT does it, what the authors can try to show is that, hey, they obtained access to my work and ingested it, and that it's not. And so they're focusing not so much on the output or the product.
I see.
But they're saying, how does this software even know my style? The only way it would know my style is if it had access to my style, and it hasn't paid for that.
Okay. Yeah. Okay.
Yeah, I mean, if I buy a Stephen King, well, like you pointed out, if I buy a Stephen King book and I read it and I'm like, I love the way he writes, I'm going to try to do that. But it goes back, John, we're talking to John Rizvi, remember, and I think we even talked about this case one time, the subconscious, whatever, I forget what it was, subconscious appropriation or something back in the day with George Harrison and he lost the case. He got sued for subconsciously stealing the lines from another song. Right. It was the rhythm from another song. And and he actually lost that case. Now, in this case, what we're seeing here is it's not subconscious. This is consciously happening as far as a machine can be conscious.
Yeah, exactly. And ultimately it's going to become an evidence play, and that's what I think is going to be really a huge risk for ChatGPT. Is in order for them to defend their position, they're going to have to reveal their methods and the database. And if they do that, then it puts them it suddenly opens them up to wholesale copycat software out there. Right now, ChatGPT's got like a leading position in the market on doing what they do. But if they reveal their methods and their database, then you'll have a bunch of other ChatGPT copycats that are charging significantly less, and maybe even they'll offer the service for free, as in, to get eyeballs for advertising, and then ChatGPT would essentially be destroyed in the marketplace. So that they're at a tough spot right now. I mean, I ultimately think in order for their survival, these cases would have to be settled out of court to avoid revealing their proprietary trade secrets on how they're getting this information.
John, quickly, do you think there's a scenario where ChatGPT or OpenAI, wherever the company is, that they just get sued over and over and over, and they just disband because they say they can't do it? Now, I think the cat's out of the bag. There's no way this form of AI is going to be stopped, but do they themselves, maybe as a company, be forced to say, look, we're just out of interest of lawsuits, we can't do this no more?
Yeah, so that's a risk. I mean, what if, and that's, again, where for the plaintiffs, possibly a confidential settlement is better for them than really pushing hard and getting some enormous award. Because if they file for bankruptcy and there's no funding, and then they're in line with everybody else to try to get payment, they may be better off accepting a settlement instead, while the company still has funds left. Like, if they are essentially the biggest infringer in the history of the world, they certainly do not have the funds, the profit to pay for all of that infringement.
All right. With that, John, we will let you go, buddy. It is always a pleasure. John Rizvi, people want to find out more, they can go to the patentprofessor.com. Is that correct, sir?
Yeah, exactly. Or type in on Facebook, Instagram, TikTok, The Patent Professor, anywhere, and we'll come up.
Thank you, buddy.
Awesome.
Thanks you.
So, yeah, I'm with you, man. There's going to be lawsuits out the yin-yang here on this stuff.
But then, at some point,